Hi, everyone. Thank you for joining me today. I'm Melissa Garcia, and I am going to be presenting today's webinar, What Requires a Homeowner Vote? Really excited about this, as I am to teach any kind of webinar for ACE, for Altitude Community Education. So the webinar name, I already said that. See, I'm supposed to read these housekeeping things, and I always forget. So on your screen, you should primarily be seeing the PowerPoint presentation. You should additionally be seeing a small box on the left-hand side of the screen with the presenter, me. On the right side of the menu, you will see a private chat icon. Please use this icon to type in your questions throughout the presentation. Questions will be addressed at the end of the webinar, time permitting. I will make time. If you have audio or video issues during the presentation, please click the No Audio or Video button below the PowerPoint on your screen and follow the instructions. One CMCA credit will be automatically generated and emailed to you within 48 hours after the webinar, assuming you attended the entire program. These credits are not transferable. Please email education@altitude.law if you have any questions about the webinar or receiving your CMCA certificate. As a reminder, this presentation will be recorded and added to the Altitude YouTube channel within a couple of days. And it's also on our website, because all of these webinars, if you just navigate to the top of the screen on our website, you'll see a place for webinars and videos and blogs. Just click on that and then you'll find the webinar section. And then under that, the most recent one will be on the screen, and then you can always navigate to the other ones as well. Lastly, there will be a survey that will pop up at the end of the webinar. We truly appreciate any feedback you can provide. Your thoughts and opinions assist us with improving our future presentations, so please don't hold back. All right, what requires a homeowner vote? So one last thing I want to talk about, I always talk about the next class and let you know what's coming up for October. And I love the name of this. It is Sneaky Governing Document Provisions That Can Bite You in the Booty. So I just want to see that just for the title. I hope you do too, and I hope you join us. Okay, so what requires a homeowner vote? Explore the hidden owner approval requirements not explicitly found in governing documents. This is important because, as you may or may not know, the legislature has changed a lot of the laws over the last 20 years. And even prior to that, there's been a lot of laws that supersede or fill in gaps which would require homeowner approval when you didn't realize that, either because your documents might have been missing something or because the statutes supersede whatever is in your governing documents. So we're going to go over those today. I think I got most of them. If there was one that you thought was in there and I didn't touch, you can certainly email or text me or put it in the chat. It's okay, you're a minute late. Whoever just added themselves. Okay, so where does owner approval come from? I don't know if you're able to see the cartoon there. I can't even see it. Can't give this to the HOA board. Far too easy to understand. We need to use more legalese. No, we don't want to use more legalese. What we're trying to do usually is to rewrite the documents to get rid of the legalese. But sometimes there is legalese that we have to use. And a lot of the times that comes directly from the statute. Because for whatever reason, we like to write bills that are very difficult to understand. I call it job security because I have to interpret. But and I love to laugh at my own jokes, so just go with me. But where does the owner approval come from? So boards and managers, whether you're a new board or new manager, or you've been a manager and board for a long time, you need to understand that each association is different, and each association has governing documents that will drive what the parameters are for the association, and whether there's rights or limitations of owners or the board or a committee. All of that is driven by the governing documents. And I put the three right here: governing documents, the declaration, the articles, and the bylaws. And I quickly want to talk about those three. But just keep in mind, particularly with new managers, that although you might see the same types of provisions in several documents, because maybe you manage a lot of communities that were developed by the same developer, There are so many nuances with association documents. So don't think that just because it's always been or said this way on 90% of the documents doesn't mean the other ones might say something else. So you just got to be really careful and scrutinize when you're reviewing for these things. But essentially, each document works a different way. The declaration, that's the most important document. That's the one that establishes all the use rights, all the maintenance, all the assessment provisions, all the meat of the documents. Then there's the Articles of Incorporation. I'm going to say that's the least important because all that does is establishes the purposes and the general purposes of the association and some of the, it's what I like to call the birth certificate of the association. And then there's the bylaws, which is probably the most important for the board because it's the operational document. So it has things like how to operate the meetings, what kind of notice do you have to give out, how to elect directors, all of that kind of stuff. So it's really important, I think, for boards simply because that's the one that they're probably going to be accessing a lot right around annual meeting time and maybe throughout the year with things like records requests and those kinds of things. And it's the one document I think that's been amended quite a bit when it comes to statutes overriding, which are that's the next bullet points. Statutes overriding documents. In the last 20 years, there's been so many revisions to the statutes that serve to supersede what's in your bylaws. And they are geared towards transparency. You see a lot of new provisions that are related to becoming more transparent, boards becoming more transparent and required to be more transparent to the owners. So a lot of those changes are in the bylaws. And if you haven't had your bylaws rewritten in 20 years, then it's going to be a surprise at how many things that are probably contrary to Colorado law. But the statutes, there are a lot of statutes that might apply to associations, but the main ones are Kiowa and the Nonprofit Act, which let me go ahead and I think that's in our next, yeah. So let's talk about each one of those because we're looking again for the basis for owner approval requirements. And the basis could be in either Kiowa or Nonprofit Act. And those are the two that I'm going to discuss today. So Kiowa, that's the Colorado Common Interest Ownership Act. And you need to, I know those of you who have been around for quite some time know that there's a pre and a post Kiowa distinction. Anything on or after any association that was created on or after July 1st, 1992 is a post Kiowa community, which means all of Kiowa applies. And when I say created, that means the declaration was recorded on or after July 1st, 1992. Anything prior is pre-Kiowa, and only those provisions that are listed in 3-117 apply. So just make sure that when we're going through this, I'm going to talk about which ones only apply to post. I have notated them on the PowerPoint slide, and it could be a little tricky if you're not realizing that this is just post. You might be applying some owner approval requirements that are not necessary because they're only applicable to post Kiowa communities. Okay, so the other statute is the Nonprofit Act, the Colorado Revised Nonprofit Corporation Act. And these provisions, I mean, Kiowa, between the two, if there's any inconsistency, Kiowa controls. And Kiowa really does provide a huge framework that established how to create an association, what's required to be in the declaration, how to manage it, how to change things, certain minimum requirements for insurance, for example. There's a lot of, all the meat is in Kiowa. But the Nonprofit Corporation Act, that is also applicable to all common interest communities. And there's no pre or post distinction. So the entirety of that statute will apply to associations. It's just any nonprofit corporation is going to be subject to this statute. And the types of provision in the Nonprofit Act are more like the bylaws, the operational things, like, once again, meeting requirements, how to take action by email if you're a board member, records, additional records requirements. So those kinds of things, instead of the main meat of the governance, such as use restrictions and assessments, all of that is in Kiowa. But to the extent either of these two statutes are conflicting, Kiowa is going to control. So when looking for, we're going to look at these two statutes and go through them when determining which statutes provide owner approval that either supplement or supersede what's in your governing documents, and you need to know about it. So general rule of thumb, the board takes action on behalf of the association for everything except what is expressly reserved for owner vote in either the governing documents or the law. So you're going to be looking at both of them. And I'll give you, and again, it's going to depend on whether it's a pre or post Kiowa association. That's going to dictate whether or not owner approval is required for certain provisions under Kiowa. But I'll give you an example for this one. If you're at an annual meeting and all of a sudden somebody stands up and says, I want to fire the landscaping company, that particular action is not something that's typically reserved for homeowners to vote on in the governing documents. I don't think I've ever seen that. I think I see it sometimes applied to management companies, but really not landscaping companies. And it's not something that's required under either statute for owners to approve. So that is not something that is expressly reserved for owner vote in either the statutes, and probably not in the governing documents. Most of the governing documents will say something like the board has the right to enter into contracts and hire vendors. And that's what the statutes say as well. So that's an example. If that happens at the annual meeting, that's the example of where, there might be this great cry of, we don't like this particular thing or action or vendor, but that's reserved for the board to vote on. The board to vote on behalf of the association, because it falls under this general rule of thumb. This is also, and I notate it later, in 38- in Kiowa, 38-33.3-3031A. Now, again, that's notated later, so you don't have to write that down, but that's the general rule of thumb. If it is not a post-Kiowa community, then it's still typically the general rule of thumb that the board takes action on behalf of the association for anything that is not reserved under the documents or the statute. And typically the governing documents themselves say the same language. So I just wanted to remind you of that. Okay, so let's talk about owner approval under Kiowa. And again, we're going to let you know whether these apply to just post-Kiowa communities. I tried to capture the most relevant provisions that we discuss, and I might have missed a couple, but the ones that come up with our firm all the time. And also, if you don't have a copy of Kiowa, it's on our website. So definitely on the homepage, it's right there. It's updated for the newest laws, even for this year. So it's updated through August 7th of this year. So all that stuff is in there. And if you're looking at wondering what laws were changed over the last several years, make sure you get on our website, because we have the legislative tracker. If you get onto the legislative section on our website, hit that and it'll show, there's one section that shows today's laws, and then another section that shows all the laws for the last, I think, maybe 5 or 6 years, and kind of summarizes them so you can check it out for yourself. Okay, let's get started. So when you see that 3-118 under Kiowa, remember the first part of Kiowa is 38-33.3 blah. So that's what that means. I'm just quoting the last part of it. So 3-118, some of these are just things I want you to know about, but probably don't come up too often. This is opting into Kiowa, and this applies to those pre-Kiowa communities that want to become post-Kiowa communities. And if they want to become post-Kiowa communities, then owner approval is required, and a certain process must be followed under 3-118 of Kiowa. Now, when this comes up sometimes, the only question that usually comes up is, if I am rewriting my declaration or my governing documents, and I'm a pre-Kiowa association, and I'm rewriting it, so during a time which is now post-Kiowa, does the association automatically become a post-Kiowa community? And the answer is no. Just by rewriting the documents doesn't create a post-Kiowa community. You're still a pre-Kiowa community. But if you want to opt in, then use that provision. The second one, 3-120.5, this is extension of declaration terms. This has to do with, again, pre-Kiowa declarations that have limited applicability language. Things like, it'll say something like, this declaration is valid until 2029 or 2023, whatever it is. And then after that, it's deemed expired. And typically there's language in there that says, unless prior to the expiration date, the owners take action to approve an extension or to approve some kind of amendment. So what this does, even if, let's say that happened, let's say you have a declaration, a pre-Kiowa declaration that terminates 2023, and the owners had failed to approve an extension, this allows the owners to approve an extension even though the initial original expiration date has already passed. So it's a limited scenario, but if you have one of those pre-Kiowa declarations with those limitations on them, then this allows you to submit that amendment and that extension to the owners for approval. Now, this section, 3-120.5, only allows the board to propose an amendment to extend the declaration, no other amendment. So don't add that to something else. It is for the limited purpose of allowing an extension of an already expired pre-Kiowa declaration term. And the requirement is 67% of the owners will have to approve that extension or any higher requirement. And so this actually allows the higher requirement, and we'll talk about amendments later, but this particular provision actually allows the higher percentage if it is stated in the declaration. So if your pre-Kiowa declaration said 75% of the homeowners are required to approve an extension of the declaration term, then you have to use the 75%. Okay, all right. And then finally, the last one, creating a new community. This is only applicable to post-Kiowa communities. And this is the situation where it's really just, it's applicable in two situations, but primarily it's developers who are wanting to add property as they're developing in phases and add property to the community. And it essentially just says, the owners of the real estate that's going to be added to the community have to sign off on being added to the community. So typically this would be applicable to just the developers, but it also is applicable to that situation where you already have an existing community and you're trying to annex property after the fact. So you're already through your additional development of the community. There's still some annexable property, and you want to add those. Again, the property that is going to be added, the owners of that property must sign off on that annexation. So that was actually, this was added this year under HB 24-1383. So that's where that came from. Okay, moving on. Limited common elements. So this is the one where you have to be careful because it's a post-Kiowa community, and oftentimes I see this sometimes being applied to pre-Kiowa, and this has no applicable to pre-Kiowa associations. But this is the scenario where you have a limited common element. And for those of you who are new or forgot what a limited common element is, it is a part of the common elements that is exclusively delegated or assigned to one unit or less than all units. So for example, with condo communities, you have balconies. Now those balconies may be part of the common elements because they're outside of the unit boundaries, but they are exclusively used by the unit that they're attached to. So that would be a limited common element. What this section applies to is reallocation, meaning swapping or changing and reassigning limited common elements, and assigning limited common elements from prior general common elements. So taking a common element that used to be a general common element and allocating it to a unit or less than all units. And I'll give you an example of both. But for the first one, swapping car spaces. That's probably the one that I always see most of the time. Limited common element parking spaces that are assigned to particular units. And let's say a couple of units want to swap. One wants one and they just want to swap somebody else. So that is allowed for post-Kiowa communities, and it's specified the procedure under 3-208. And under that procedure, if you just navigate to that part of Kiowa, you'll see that it requires the owners to submit an application for approval of whatever that allocation is. You also have to, they're supposed to include a proposed form of the amendment to show what the reallocation is, because this requires an amendment to the declaration to reallocate those LCE spaces. So you can't just say, oh, we approve and then don't record an amendment. This requires recording of an amendment. And the application is also supposed to include a deposit of the attorney's fees that will be necessary to review and or draft this amendment. So typically what happens is the association or the owners, they just request, can the association's attorney just draft it, and then they pay for it. So these owners pay for all of it, not just putting the deposit down, but also if the costs to accomplish this exceed the deposit, then they have to pay for the extra costs as well and fees. And what it does say also in this section of Kiowa is that this is subject to any provision of the declaration. So what that means is, first of all, if the declaration is silent, you just follow these procedures. If the declaration is not silent and it adds something else, then this section of Kiowa allows the association to require additional requirements, for example, or maybe subject to some kind of criteria, whatever it is. But Kiowa says very specifically that this procedure is subject to any provision of the declaration. So just keep that in mind. Now, if this is a pre-Kiowa association, then it's document specific. There's nothing under the Kiowa that you can say, okay, this is what the procedure is. So just look for any specific approval requirements of the declaration. And if there's none, look for general authority of the board to just take action on behalf of the association. If there's nothing there, look for whether there's something that prevents the board from taking away a common element right and allocating it to a particular unit, or prohibiting the swapping. So there's a lot of things that could serve to dictate different procedures and requirements under pre-Kiowa documents. So be careful, and if you're not sure, you really need to talk to your counsel about that, and let them review it for you and tell you what those procedures are. So the second part, can allocate a common element not previously allocated. That's the situation where you have general common elements and you want to assign things to units. And so, for example, parking, maybe there's a ton of parking, and that's never the case, but I'm going to use that as an example anyway. But let's say there's a lot of parking and you wanted to go ahead and assign parking spaces as limited common elements to particular units or to all the units. Maybe you have enough spaces that you're going to say, we're going to allocate one limited common element space to each unit. So what the post-Kiowa, what 3-208 says is that, here's a quote, that you can do this pursuant to provisions in the declaration made according to 2051G. And what's 2051G? 2051G is essentially that section of Kiowa that says, here's all the stuff that needs to be in your declaration. And that particular provision has to say that, has to describe the real estate that could be subsequently added as, or allocated as, limited common elements, and a statement saying that they may be so allocated. So the declaration itself has to state that the association does have authority to allocate common elements as limited common elements. And it has to state that with respect to any kind of allocation other than limited common elements that are already statutorily allowed under 2021B. So I know that's a lot, but essentially if you are a post-Kiowa community and you have general common elements that you want to allocate as limited common elements, your declaration is going to have some language in there saying these portions of the general common elements or all general common elements may be subsequently allocated by the association as a limited common element. If it doesn't have that, then it doesn't fit within the section of 208, and you're not going to be able to do it unless you amend. Now, the other thing is it discusses those statutorily described limited common elements. It's just essentially acknowledging that there's a part of Kiowa, 202(1)B and 1D, that say, to the extent not otherwise provided in the declaration, here are all the limited common elements. Things like, I remember window boxes, windows, doors, limited common element doors, balconies, patios. So it just kind of lays out a bunch of standard LCEs if they're not stated in your declaration. Those are the ones that are statutorily allowed. But outside of that, there needs to be the language saying that you have the right to allocate general common elements to limited common elements, and you still need the amendment. But keep in mind that fortunately, this is the kind of amendment that you don't have to get approval for. So none of these amendments need approval by the owners because there's an exception under Kiowa that allows the board to approve the amendments. A lot, but this comes up all the time, so I really wanted to go into detail on that. And then if you have further questions on that piece, you can always contact me. Okay, the last thing, what about modifying the LCE itself? So the statute doesn't address that. It doesn't say you have to get owner approval for modifying a limited common element. That's very different from reallocating. So modifying, what I mean by that is if you're going to upgrade the balconies or change the paint color of the balconies, that kind of thing. But when you are swapping or assigning a new LCE, then you're going to have to get the approvals of the owners that are at issue. Okay. All right. Let's keep going. So the next thing, this is a big one too, 217. This is amendment of the declaration. Sorry, I need my coffee today. So amendment of the declaration is in 3-217, and you'll see that it's not just applicable to post-Kiowa, it's applicable to all of Kiowa, or all associations pre or post. And essentially what it says, regardless of what's in your declaration, is that the declaration cannot be amended without owner approval. So what is that owner approval? The owner approval is, there's a range that is allowed under 217, anywhere from, it has to be more than 50% of the total allocated votes. That's everyone, not just those who show up at a meeting, but more than 50% of the total allocated votes, or any higher percentage up to 67%. And for post-Kiowa communities, it can exceed 67% in the declaration for certain things. So if you have a declaration that says you have to get 75% approval, owner approval, for an amendment to the declaration, then in general, that is void because it's higher than 67%. It goes down to 67%. But for post-Kiowa communities, that will still apply the higher percentage for any of these listed items. And that's creating or increasing special declarant rights. So that's when you're still in the development of the community, adding or creating or increasing whatever those declarant rights are. Increase on the number of units. So if you're adding more units to the community, doesn't say decrease, just increase. Changing the boundaries of the units. So for example, if you are allowing homeowners to enclose their balcony and include that balcony as a part of the unit. So the boundaries change. Whenever the boundaries change, you can have that higher percentage of owner approval requirements for an amendment of that nature. And then finally, changing allocated interests of the unit. So what that means is the allocated interests are your allocated voting rights, your allocated expense allocations, and then for condos, your allocated ownership interest in the unit. So if, for example, your allocated voting interests were 1 vote per unit, and then you wanted to change that to say, no, voting is going to be weighted, and it's going to depend on the size or the square footage of that particular unit. The bigger ones are going to get more of the vote, and the smaller ones are going to get less. So if you wanted to change from equal voting to that scheme, that's a change in the allocation of interests. And then finally, the change the use to which any unit is restricted. You know, I think that this can be interpreted many different ways and really strictly and kind of broadly. But I think the prudent way to look at this, to interpret this, is to think of this as any kind of change to the way the unit is restricted. So for example, probably the main one would be you can use your unit for whatever reason, and then all of a sudden you are adding an amendment to add some leasing restrictions or to prohibit short-term rentals. That's the kind of thing that changes the use to which you can use your unit. And thus, if your declaration has a higher than 67 approval requirement and it's post-Kiowa, then that higher percentage is going to apply. If you're not sure, again, one of these things, you definitely need to check with your attorney and have them review it, because we've had situations where the association got 67%, thinking just automatically that the 75 or 80% was not valid because of that initial part of Kiowa, but then only to find out, wait a minute, the higher percentage applies to these types of amendments. So you need to be very careful. For pre-Kiowa, that doesn't apply to that higher percentage doesn't apply to pre-Kiowa communities. So any pre-Kiowa declaration, whatever the amendment, whatever amendment you're trying to do, if your pre-Kiowa declaration has a percentage that's higher than 67%, it's deemed to read 67%. Okay. There's a bunch of exceptions for amendments that would otherwise require owner approval. They're all laid out here. I might not have put all of them in here, but I put in the things that I sometimes see and need to use them. And there are things like correcting, this is for the developer, correcting clerical typos, technical errors. Associations have used this sort of Scrivener's error as well, just to correct things that were obviously just typos, nothing substantive. Complying with mortgagee HUD FHA requirements, and again, this is more the developer. Allocating the LCE, a common element that wasn't previously allocated, as well as exercising development rights. Excuse me, and that's stated for the declarant. Arguably, you can say that many of these declarant rights, once the declarant's gone, now transfer to the association, but there is no clear statement about that. The other one is for amendments executed by the association. We already talked about the LCE reallocations, relocations of boundaries, and subdivisions of units. And so those are just exceptions to when an amendment to the declaration would not require homeowner approval. So the court petition process, I put that in there just because the court petition process is a process used when you're trying to amend your declaration and you can't get enough owner approval, not because of objection to the amendments, but because of apathy. You can't get enough people to respond. So you can't change your declaration, not because of objection, but because of apathy. So there is a process under Kiowa. We won't go into that today, but it essentially says, look, if you satisfy certain approval requirements, meaning at least half of the owner approval requirement is obtained, and then no more than a third of the owners object, no more than a third of the mortgagees, if they're required to approve, object. So, and you jump through these other procedures, you can get that amendment passed to the declaration through the court petition process. And there are some exceptions, but I put this in there because it doesn't require the entirety of that owner approval. It only requires half of what's stated in your declaration. I did want to say, though, that if your declaration says you need 100% to amend the declaration and you're trying to take advantage of the court petition, it's half of the 100%, not half of the statutorily reduced cap of 67%. It's half of whatever is stated in your declaration. Okay. And I see the questions coming up, but we will go through all of them as at the end of this presentation. Termination of communities, all that is if you're actually going to dissolve your association and terminate the declaration or the community, maybe it's because you are a sub-association and everything is taken care of already by the master, so you don't need the sub, or maybe you have 4 units and there's really no need for an association because the only thing you're doing is maintaining this little grassy patch of area. Whatever it is, there's an ability to terminate the community as well as dissolve your association. And for post-Kiowa communities, you're required to get owner approval, 67% or any higher stated percentage. Same thing for merging or consolidating associations. Again, this is post-Kiowa. And there are some different provisions for pre-Kiowa for both of these. Owner approval is the same as whatever is stated for the termination. And if nothing is stated, then it's 67%. And majority of vote, assuming at least 75% of the community participates, then you can withdraw from a merged community. I don't even know why I put that in there. That's not something that I ever hardly see, but there it is. Okay, this is a biggie. The budgets. So post-Kiowa associations, oh, that's the second piece, hold on. Post-Kiowa for 303 subsection 3, post-Kiowa communities, the board cannot elect members of the board or determine qualifications, powers, and duties and terms of the board. Now, that election of the member of the board is also in the Nonprofit Act, so it applies also to pre-Kiowa, but I just wanted to show the Kiowa section that says the board can't do this. So if you are a post-Kiowa community, what that means is obviously elect members of the board. That's an obvious one, but determine the qualifications. That means you can't amend your bylaws to say, in order to be a board member, you must qualify in these ways: be an owner, be current in your assessments, be, not violating the documents. You have no right as a board to do that. That has to be approved by the owners. Same thing as powers and duties of the board. You have no right to establish or change what those powers and duties of the board are, and they're usually listed in the bylaws as well. And you also can't establish the terms of the board, which means how long a board member can serve. So you can't change it from 1-year terms to 3-year terms, for example. So that is all post-Kiowa associations. For the budget veto, this is applicable to all associations, but it is certain, there's a certain exception for pre-Kiowa associations. So this used to only apply to post-Kiowa, but several years ago, the Kiowa was changed to apply to all associations, pre and post. And it essentially just goes through, I'm sure all of you know what the budget veto process is, but really quickly, it essentially requires you to, as a board, adopt a budget, then provide or submit that budget, that summary of the budget, to all owners. You can mail it, you can stick it on the website, you can email it, you can do all of that just to give them the summary. But then you have to call a special meeting or do this at the prior to or after the annual meeting and submit it to the owners for an opportunity to consider, as well as an opportunity to veto. And that just means instead of getting the owner's approval, you have to, a certain number must veto it or it's deemed approved. And that number is a majority or anything higher, majority of all, not a majority of just those at the meeting, but a majority of all or any higher percentage stated in the declaration. So you submit the summary of the budget, you send the notice by mail according to your bylaws and statute. And at that meeting, owners get to consider it and then veto it. Now, if your documents provide that the owners must approve it, then that's something that's stricter than the statute. You're going to follow that part of your governing documents. But if it's silent or it just defers to the statute, then it's this budget veto process, and it's the majority of all must veto or it's deemed approved and ratified by the owners. The exception is for pre-Kiowa associations if in their declaration they already have some kind of maximum assessment cap or threshold over which owners have to approve that increase. So if you have a pre-Kiowa declaration and it says that the board can adopt the budget, but anything over 10% over last year's budget or last year's annual common expense assessment must be approved by owners, then you follow that piece. You follow that provision of your documents, of your declaration. You don't use the budget veto, you just follow your own declaration. And remember, this is only for pre-Kiowa declarations that have this language is already setting a threshold over which owners will have to approve that budget. So even if the board, you're still within that, that amount that you don't have to get approval under this pre-Kiowa exception, you still have to send a summary of the budget and allow homeowners an opportunity to consider it. So that's still applicable to the pre-Kiowa association. But if your pre-Kiowa declaration contains that maximum assessment language, then you don't follow the veto, you follow your declaration. Okay. Others, transfer of declarant control, all this does, these two sections, they prescribe the statutory timeframes for declarant control being transferred to the owners. So 6 and 7, 6 actually just establishes when you still have a new community and it's still controlled by the declarant, after a certain percentage of units are sold that to owners other than builders or developer, then the homeowners get to elect the board members. And it's just a transitionary period. It establishes 3 different timeframes where the owners are going to be able to elect, or you're required to get owner approval to elect additional board members. And then 3037 is just the expiration of the declarant control period. That's all that states. 3038 has to do with removing board members. So this is a post-Kiowa community. And what this applies to is when homeowners want to recall or remove a board member or the entire board. For post-Kiowa communities, this is the approval requirement that's going to apply. And this is regardless of what your documents say, what's typically in the bylaws. Regardless of what your documents say, owners by a vote of 67% of at least a quorum must approve the removal of a board member. And again, this is post-Kiowa. Pre-Kiowa, that's essentially, whatever your docs say, but we'll get to that because that's in the nonprofit tax section. And then finally, 303.5, the construction defect statute. I am not going to go through that. You have a lot of great construction defect law firms that can tell you all about the procedures for construction defects, but notice now that there is owner approval required. There didn't used to be an owner approval requirement for moving forward with a construction defect lawsuit. There is now. It's a majority of the votes allocated. Okay, moving on. Conveying common elements, that just means if you're going to sell a part of your common elements or your common area to a third party or subject it, get a mortgage on it, subject it to some kind of security interest. For post-Kiowa communities, you need 67% of the entirety of the community, not the quorum, but the entirety of the community to approve any kind of conveyance or subjecting common area to a security interest. And it also allows for a higher percentage to be stated in the documents. And I do see the documents sometimes, the declarations sometimes say something higher than 67%. So just be careful and look at your documents. It also requires the owners to approve the actual agreement. So there's going to be a conveyance agreement that spells out the terms, and the owners have to approve that as well. So typically you're approving both of them together. You're approving the sale as well as the agreement. But again, this is post-Kiowa communities. For pre-Kiowa communities, just follow your docs. And some of the documents will say a certain owner approval. If they don't say owner approval, look for the board authority. But even if they don't have board authority, there's provisions in the Nonprofit Act that allow the board to take action to convey and to sell common area. So just, again, talk to your attorney, because there's a lot of hidden language in the documents and you might not find it in one area. It could be in the articles of incorporation, could be in the bylaws. Just make sure that you talk to your attorney. Okay, owner approval under Kiowa continued. Now we're talking about records. And under this section of Kiowa 3-317, this has to do with the records that are required to be open for inspection and access and copying by the homeowners. So there's a certain section under 317, it's actually section 1, subsection 1, that lists all the records that are supposed to be retained for the purposes of inspection. Now, another section of it, 3173, lists those records that are within the board's discretion to determine whether or not to withhold. And this is one of them: architectural drawings, plans, etc. So if you have an architectural review application and somebody wants to see the plans that were submitted in addition to the approval and rejection of whatever that architectural submission is, then this part of Kiowa, which is applicable to both pre and post, says you cannot do that. Even if the board wants to go ahead and give those plans to another owner, this part of Kiowa says you can only do that with the written consent of the owner. So in this particular provision, I'm talking about individual owners have rights to approve something. And here's one of those sections. If it's their plans, they don't have to allow some other owner to see their plans. Now, this is different from 317 subsection 1, which actually does discuss records of actions to approve or deny an application, an architectural application. Those records that approve or deny the architectural submission, those are open for inspection. It's just all the plans and drawings that lead up to that, decision that you have to get the owner's approval in order to disclose them. And then the same with 317 3.5. This is actually a part of Kiowa that says you cannot disclose these records, and there's a list of those records. And one of those records is telephone and or email address of an owner to another owner without the written consent of the initial owner. So just some background on that. Years ago, the statute was changed to say no telephone and email addresses, period, were allowed to be provided. And then there was a little bit of backlash because many associations had community directories, and these directories were created with the voluntary provision of telephones, email addresses, addresses of homeowners who wanted to participate in some kind of community building project, and they wanted to allow others to see their telephone, email address, and call them or email them if they wanted to. So because of that backlash, the statute was then changed again to carve out this exception and essentially say, unless you get the written consent of the owner, you can't provide telephone or email address. If you do get the written consent, that written consent stays with the file, and you're allowed to do the whole community directory or provide that information, because now you have that written consent in your file. I did want to say one really quick caveat on that is that board members, there's another section, 3171, which says that board members' email addresses, not phone numbers, but email addresses, are required to be disclosed upon a homeowner's request, or a homeowner or their designated representative's request. And so that's required. What was I going to say about that? I was going to say, you don't have to post it. You don't have to post it on the website. These are records that are supposed to be provided upon request of an owner per 317. There's procedures for requesting. There's time frames for when you need to give that information. But board members' email addresses, you don't have to proactively post it on the website or send it around. It's just that if a homeowner wants it, then you have to give it to them within the statutory time frame. All right, moving on. I think we're done. Yeah, we're done with the Kiowa. We're moving on to the Nonprofit Act. And we're going to talk a little bit about the same things. I mean, we're really just kind of saying now what applies under Nonprofit Act for pre-Kiowa associations. And the first one is removal. Remember, for the post-Kiowa communities, the removal requirement was 67% of at least a quorum. So if a quorum of homeowners show up, then 67% of those who show up, assuming a quorum shows up, have to remove the director or directors or the entire board. For the pre-Kiowa associations, you look at your documents. So the documents essentially oftentimes will say a majority, and oftentimes they will say something like even a majority of a quorum. But just keep in mind that this section of the Nonprofit Act, 7128-1088, says the number of votes cast to remove needs to be sufficient to elect the director at an election, which always requires at least a quorum, and so a majority of that, of at least of a quorum. So you can't have something less than that, for example, but I don't think I've ever seen anything less than that. I think typically I see a majority of all, or sometimes I see 67% of a quorum, or sometimes a majority of a quorum. But just recognize for pre-Kiowa, look at the documents. And if there's nothing in the documents, in the bylaws or any of the documents, then it's at least a majority of a quorum. 7-130-103, this has to do with amending articles of incorporation. So there are some provisions that the statute, Nonprofit Act, says that the board can do on its own. But outside of that, it's going to require homeowner approval. And oftentimes the articles of incorporation state what that approval is. But if they are silent, then the approval will be a majority of at least a quorum of owners must approve any amendment to the articles of incorporation. But the things that the board can approve on its own, and it probably does this quite a bit, is changing, for example, the registered agent or the principal office of the association. So if you're changing your management company, or you're changing where the records are going to be kept, those kinds of things, you can do that just by getting onto the Secretary of State's office and making that change. That is allowed for the board. But also changing the name of the association by substituting the word corporation or incorporation or company for a similar word or abbreviation in the name, like Inc. or something. So there's a few things, and if you're not sure whether the board can do it on its own, just contact your counsel and they will let you know. Okay, amendment to the bylaws. I know previously we talked about for post-Kiowa communities, boards couldn't amend the bylaws to change terms and qualifications of directors or powers and duties of directors. Here's another one that is applicable to pre-Kiowa associations, not the terms and qualifications and duties and directors, but I'm going to skip here. Where does it say? I'll come back to this. Quorum. What the Nonprofit Act says that only the members can approve an amendment to quorum. And that applies to both pre and post-Kiowa communities. It doesn't say that in Kiowa, so that's why I didn't address it for post-Kiowa communities before, but this is one of those sections that's applicable to all associations. And essentially the Nonprofit Act says you cannot amend quorum for member meetings. Now, for it, either pre or post, another thing that kicks in under the Nonprofit Act is 7-13201, the first bullet point. If there's anything in your bylaws that prohibits the board from amending the bylaws, so there has to be an express prohibition against the board amending the bylaws. If you see that, then it's kind of game over. You can't amend it for anything. Everything's going to have to be provided to the owners. But if you don't have, and what I mean by express expressly prohibit, I mean something that says the board shall not amend the bylaws, or something that says only the owners shall amend the bylaws. Not something like the bylaws may be amended by owners. That to me is not an express prohibition of the board to amend the bylaws. So I think in that case, the board can still amend the bylaws. But again, if it's a post-Kiowa community, then they can't amend quorum, terms and qualifications, or powers and duties of the board. If it's a pre-Kiowa community, they cannot amend quorum or anything under the next two bullet points, which you really have to talk to your attorney whether or not those apply. But there are sections of the Nonprofit Act which again require only owner approval. They're rarely, if ever, used. So just check with your attorney if you're wondering if, as a pre-Kiowa association, the board has the right to amend the bylaws for something other than quorum. Chances are you're going to be able to do it, but just check with your attorney. Merger and dissolution, again, these are already addressed under the Kiowa provisions. The same requirements are under the nonprofit. They defer to the governing documents themselves. If they don't have an approval requirement, then, and when you're looking at these, the merger and dissolution, look at your articles of incorporation, look at your declaration, look at your bylaws, look at everything, because they might be placed in different documents, so you need to make sure you look at everything. But if they're silent and there's both merger and dissolution, there is I believe it's, and I'm sorry I didn't get this approval requirement stated in there, but I believe it's a majority. I think it's a majority for the merger and then maybe 67% for dissolution. I apologize, I didn't look at those particularly, but if you have questions about that for a pre-Kiowa association, then just let me know and I can look at that for you. Okay, but don't forget to always check with legal counsel if you are unsure or have questions. I mean, so many of these things, I want to emphasize that simply because the law changes every year, it seems like these days. And so some areas that I covered today might be different tomorrow. So if there's any question of whether or not owners are required to approve something, that's a big deal because you know, that if you're challenged and you've gone through and spent time, money, efforts pursuing an action under board authority only to find out later you needed owner approval, you know, that's something that you could avoid if you just have that one quick conversation with your attorney. Okay, that is it. So let's go over here to the questions. Would any homeowner vote be required to allow the Architectural Review Committee change or further restrict owner selection of exterior paint colors or paint schemes? Referring to architectural rules, are these simply suggested guidelines and not enforceable either post or pre-Kiowa? So architectural guidelines are not just suggestions. And even though the word guideline is in there, they are enforceable like any other governing document of the association, whether it's the declaration, bylaws, articles. They're simply additional supplements of and clarifications of the authority that's already stated in your declaration. So if your declaration essentially will say something like, the board, or it might say the Architectural Review Committee has the right to adopt and enforce guidelines that serve to clarify your architectural provisions in the declaration. Those are enforceable. But when just like rules and regulations are enforceable, but rules and regulations and architectural guidelines, they cannot be contrary to any of the other documents, the declaration, bylaws, or articles. They can't be contrary to the law. They can't exceed the scope of authority that's provided. So there's a lot of scrutiny that has to occur with respect to guidelines that you should really have your attorney review them to make sure that they are valid and they're not contrary to some law or to other parts of the documents. They're at the bottom of what I like to call the hierarchy chart, which is if the board adopts it or the committee adopts it, it's usually at the bottom of this chart, which means that any higher document, the articles, declaration, bylaws, statute, is going to supersede it. So you just need to make sure and understand. So is there a statute referencing that would cover specific requirements for securing votes of the members for a specific amendment? Yes. And we looked at that in the prior slide. That's 217. Okay. So it's Kiowa 38-33.3-217. That is applicable to both pre and post Kiowa associations, and it establishes the range, the amendment range that you must be within. But there's exceptions to that amendment range. So just go back to that slide and you'll see the discussion. Are homeowners allowed to contact board members directly with questions or problems? Yes. Now, homeowners, again, you're not required to provide telephone numbers. You are required to provide email addresses. So if the homeowner wants to send an email directly to that board member, they are entitled to have the board member's email address. And I would suggest that board members never use personal email addresses or work email addresses as the same email address that they use for HOA business. Those really ought to be carved out, and you should have your own dedicated email address for HOA business. Things, something like secretary at Happy Hollow Homeowners Association.com or whatever it is. Just don't use your regular email address. And the reason why is because if you're using your personal or work email address for HOA business, then if you get sued or the association gets sued, then the council can request all of the emails that are under that email address that you use, because they could be important to whatever the specific lawsuit is. So they can say, I want to see all the emails under this email address, which happens to be a personal email address, because you're using it for HOA business. So in discovery, they can discover those emails. So that's why you really want to separate the two. Okay. I understand you cannot share ACC plans even by the owner building. The plans belong to the contract engineer. So the contract, it's the owners of the plans that would be required. You would have to get their consent. And most of the time they won't consent. So, okay. Master Association raised dues annually per CPI without vote. So the CPI index, and sometimes the documents, the declaration will say every year the annual budget, annual common expense can be increased up to a certain threshold. And oftentimes that is the CPI increase. So you kind of you use a CPI increase in order to increase your own amounts. So Master Association raise dues annually per CPI without vote, then do not allow sub-association to raise dues. This hinders sub from acquiring needed funds to maintain the responsibility for street maintenance of cul-de-sacs. Okay. Maybe that's the end of that. Oh, sorry, I should have started from the top. So what is in pre-Kiowa? A previous board put in the rules and regulations a space at the end of a cul-de-sac available for homeowners, but not in the declaration. How should current board handle? Well, first, I would make sure that you talked to your attorney about that, because there could be authority for the board to allocate certain spaces for homeowners without an amendment. And for post-Kiowa, you'd have to amend the declaration. For pre-Kiowa, you might not, but it will depend on your documents. So I would defer to whatever your documents say, ask your attorney about that. And it's a pre-Kiowa association, so it's going to be document specific. I live in a community with 4 HOAs. Can the Master Association cause amendments to specific sub-HOAs? Potentially. So oftentimes the master and a sub, there'll be language that says something like, to the extent of any inconsistency between the master and the sub deck, the master deck is going to control. So it could be that the master has an amendment to their declaration that then is inconsistent with the subs, but it will control. So in that way, it sort of causes an amendment to the requirements under the sub, even though it's not a technical amendment. It's just an amendment by virtue of being inconsistent with the subs docs. So it's tricky, because you have to look for language that says which document controls to the extent of any inconsistency. Okay, I think I got all those. What is required board versus owner approval for a special assessment due to a high insurance deductible on a covered loss? So I hate to say this, again, it's document specific. Some documents require very clearly for any kind of a special assessment that homeowner approval is required. Some documents say homeowners get the opportunity to veto a special assessment. Some documents require a higher quorum requirement and say something like a majority of a quorum may approve a special assessment, assuming you achieve this higher quorum. Some documents will have a provision specifically for insurance assessments, and that might actually require a different approval requirement or a veto requirement. So it's all going to depend. If it's silent, I would definitely talk to my attorney, because if it's silent and it's post-Kiowa, or even pre-Kiowa actually, and it's not, we talked about the budget ratification process that's applicable to pre-Kiowa now. So for documents or declarations that are completely silent on special assessments, if that assessment is going to be assessed to everybody in the community, so it's like a new line item to the budget, it's like an amendment to the budget, then if your document is silent, if the declaration is silent with respect to special assessments, I would treat that special assessment as an amendment to the budget and therefore submit it to the owners for an opportunity to veto. But there has to be nothing guiding you otherwise. Can pre-Kiowa do an amendment to the declarations with the required approval on the pre-Kiowa declarations? Yes, if the required approval in the pre-Kiowa declarations fits within the range that we talked about before, which is a majority up to 60, at least a majority up to 67%. If your pre-Kiowa declaration has a higher amendment requirement than 67%, you need to read it to say 67%. Can pre-Kiowa change bylaws with just board approval? So if you go back a couple of slides, we discussed the pre-Kiowa bylaws amendment approval of boards. And it's essentially a board of a pre-Kiowa association can amend the bylaws on its own without homeowner approval, except for quorum, and unless the bylaws expressly prohibit the board from doing so. So pre-Kiowa boards have the most flexibility when it comes to amending the bylaws on their own. Is there a percentage requirement on a vote to terminate a pre-Kiowa community? Yes, it is document specific. So it's, and we need to make sure we're looking at all the documents there, because sometimes I'll see requirements in the wrong places. Just look for everything. And if you can't find something in any of the documents about terminating that community and it's pre-Kiowa, speak to your attorney and they will give you the whatever the default requirement is. When does mortgagee need to approve amendments? That's all document specific. So a lot of declarations, whether they're pre or post, and a lot of this applies to condo declarations and sometimes townhome type patio home declarations, but many of them require mortgagees to approve as well. So the lenders, not just owners, but lenders as well. And it's going to depend on the document. I'm going to say 90% of the condo declarations will require some kind of mortgagee approval. And that's because it's necessary to qualify for the good loans and the FHA and the Fannie Mae and all that. And so developers will put that in there to ensure that the buyers of the homes will be able to qualify for some of these loans. Now, just be careful, because sometimes it'll say a certain requirement of mortgagees or first mortgagees. Sometimes it will say all mortgagees. Sometimes it will say eligible mortgagees, which means if you fit within the definition of eligible mortgagee, then only those mortgagees have to approve. And sometimes it doesn't, it says first mortgagees, but it defines a first mortgagee as an eligible mortgagee. So you have to look for that hopefully it's only eligible mortgagees, because essentially, if you see the word eligible mortgagee, typically it's defined as a mortgagee who submits something in writing to the association, notifying them of their mortgage, the address, the unit, and their name and address and all that, and submit that in writing to the association. And that's extremely rare for a mortgagee to do that. So typically when you see eligible mortgagees, that means none, because most of them don't submit this in writing. But also look at the definition of mortgagee or first mortgagee, because that definition might actually include the same terminology as the eligible mortgagee. It might say a first mortgagee is defined as a mortgagee that has a first mortgage and also submit something in writing to the association that identifies their mortgage and all that. So just check with your attorney. Can a board revise the entire bylaws without owner approval and only discuss and vote on revision at an executive session? So the ability to, first, I'm going to take that second question first. You cannot approve a bylaw amendment or the entire bylaws in executive session. So that's one of the things that statutorily under both Nonprofit Act and Kiowa, you're not allowed to amend the articles or the bylaws in executive session. So that already answers that question. You can't do that. But the question of can a board revise the entire bylaws without owner approval? It depends. If you're post-Kiowa, yes, except for, and when quorum, powers and duties, and terms and qualifications of the board members. So if you leave those sections alone and there's nothing in the bylaws that expressly prohibits the board from amending them, then the post-Kiowa community can do so. If it's a pre-Kiowa, same thing. You can amend the entire bylaws except for just quorum. That's the only thing that's required to be approved by owners for pre-Kiowa. And there can't be an express prohibition against the bylaws or against the board from amending the bylaws. We're getting to the bottom here. Can a group of homeowners decide and vote to eliminate a common element amenity because they do not use the facility? Yes, and I want you to be very careful about this because a lot of this is document specific. So I'm getting this question a lot actually, so I think I might do a blog post on this. But say the association wants to close the pool because maybe they don't use it, or maybe they don't, they can't afford the repairs, or a tennis court. They can't afford the repairs and nobody ever uses it. So keep in mind that there was, I don't have it in front of me, the specific bill, but a specific Kiowa was amended. I think this was in 2022 to state that if you're going to close, well, there's a legislative intent that you keep all amenities open. And this is because homeowners bought into the community and pay assessments in order to access these recreational amenities. And so when COVID came around, so this is after COVID, when COVID came around, people were very upset that the facilities were closed. Even though they were mandated to be closed, they were still upset. So this was this bill was kind of born from that scenario. So now there's a clear legislative intent that you must keep your facilities open because people bought into the community needing or thinking with expectations that they would be able to use them. And so you can't anymore just essentially say, well, we don't have any money, so we're going to keep it closed. You can't do that anymore. So you're either going to have to budget to repair or replace that amenity, or repair it and open it, get that underway, or you can repurpose it. And by that, that's kind of your question about deciding to, well, your question is to close it. You can't just close it. You're going to have to figure something else out to be able to use an amenity because of that new bill. But if you were going to replace it, for example, from a tennis court to parking, or a swimming pool to parking, or parking to a swimming pool, whatever that is, there is language in the statute for post-Kiowa associations that allows post-Kiowa associations to modify, change use of common elements. And there's a lot, there might be things in the declaration itself that says very clearly the board has authority to change use of common areas and facilities. So if you have that language, then you can use that as the board being able to do that. But I would not do that ever as a board, particularly if, even if you have the right, I wouldn't do that until you thoroughly canvassed the community, because that's a big deal. To get rid of a pool for parking could be just a nightmare politically. So even if you have the right to do it, I would seek either input and survey and canvass, and or just get owner approval, just so you have something to support your decision. The other thing, if your declaration specifically references that amenity, so it says a pool is available, even if it's in the plat and there's a pool available or there's a tennis court available, I would want you to amend the declaration to remove reference of the specific amenity, because it could cause expose you to liability, or cause an argument that, hey, I bought into this community thinking that a pool was going to be available because it's stated right here in the declaration. So I would amend the declaration to get rid of any kind of reference to specific amenities, and instead replace it with the association has amenities, and then add that change in use language. So it's all gonna depend on what kind of authority you have in your declarations and your documents. Even if you don't have authority, even if you do have authority, get a survey done. And if you have specific reference in your declaration, get an amendment to the declaration done to remove the reference. I don't understand why there is a max percentage. Are you saying there's a higher percentage for certain kinds of things being voted on? Yes, when I was talking about a max percentage, that 67%, the max percentage is stated under the law. So under Kiowa, and I think that's what you're talking about here, but under Kiowa, if you're going to amend your declaration, there's a max percentage of homeowner approval requirements that applies. So if your declaration says you have to get 75% of the owners to approve an amendment, then that is statutorily reduced to 67%, unless you're a post-Kiowa community and the type of amendment falls under one of those exceptions that I laid out. There's like 5 of them in one of the slides. So if you're post-Kiowa community and your declaration has a higher owner amendment approval requirement than 67%, then that higher approval requirement is going to apply to those 5 or 6 exceptions that were in one of the slides. And just reach out to me individually if you have more questions on that. We're nearly done, sorry. So even if it's just one parking spot, it requires a vote of all owners. I'm not sure, so no. When we were talking about swapping spaces, it only requires the approval of the owners that want to swap the spaces. If we're talking about allocating a specific LCE space to a unit that is part of the general common elements now, and you want to allocate that to an owner or to designate it as a limited common element, then that's another one of the exceptions that's under 3- I think it was 208, which allows the association to allocate it as long as the declaration says that general common elements may be allocated as limited common elements, and it includes that statement. And again, that's for post-Kiowa. For pre-Kiowa, it depends on your documents. It's all document specific. Okay, a couple more. If a board sues a contractor, do they have to get homeowners' approval? During the lawsuit, are homes for sale at a standstill? So if a board sues a contractor for construction defect, this has to do with lawsuits with respect to construction defect, then yes, there is a specific procedure as well as an approval requirement under Kiowa. And it's in one of the slides. Sorry, I don't know that off the top of my head, but you're going to have to get owner approval. And then it says, during the lawsuit, are homes for sale at a standstill? I'm not going to say that they're at a standstill, but there is, they're not as marketable if there's a lawsuit going on, and you have to disclose that. And homeowners are not going to want to, potential buyers, if they see that there's a construction defect lawsuit, then they might not want to pursue. So maybe they're at a standstill for both sale and refi, maybe not. Usually I believe the lawsuits maybe last, I think I heard at a CAA course, maybe like 18 months is the average. So most likely it will inhibit sales and refis, but that's not a certainty. If you totally rewrite your declaration, does the post or pre-Kiowa apply? If you, well, it depends on, okay, so if you're rewriting your declaration, and you're a pre-Kiowa association, you apply to, the amendment provision of Kiowa applies to you just like a post-Kiowa community. So it's going to depend, if you're totally rewriting your declaration, but within that rewrite, there are sections that, there are sections within that rewrite that fall under the 5 or 6 exceptions that require a higher owner approval requirement for post-Kiowa, then you're going to have to follow the higher owner approval requirement. And that, I know I'm saying that in circles, but it, just contact me if you have specific questions about that. But it's going to depend on what you're trying to amend. And rewrites mean amendments of all provisions, which means that the higher approval requirement might be triggered for post-Kiowa. Okay, there's a little smiley happy face there. Yay. Okay, I think that is it. Did I get everybody's? Oh, a couple more. And for those of you who have to leave, thank you so much for attending. But let me just, okay. Oh, I already. Does the email rule extend to appointed committee members? I don't know. And I do have Kyle in front of me. I can't remember. So the email rule, which means that board members' emails are required to be open for access to homeowners. And the question was, does this also apply to committee member email addresses? It might. I'm going to check right now. Blah, blah, blah. List. Just says board members and officers under Kiowa. It does not say committee members. However, ask me offline because there might be something in the Nonprofit Act that says that any of the requirements applied for board meetings or boards are also applicable to committee members. So I'm sorry, I don't know that off the top of my head, but if you want to reach out to me after this, I will look at that for you. Okay, sorry, I will call. Could you address the CTA that we'll implement in January? Sure, really quickly. So the CTA, Corporate Transparency Act, that is a law that was enacted in January 1st or became effective January 1st of this year, 2024. And it requires associations to file what's called a beneficial ownership information report with FinCEN, which is the Financial Crimes Enforcement Network, by January 1st, 2025. This law was intended to combat financial illegalities. And they think when they adopted this law, they figured that associations are the perfect, I guess, the perfect entity to hide money, sort of like shell corporations. And they think that maybe board members, since they have lots of control over the decisions of the association, they can somehow use the corporation as a shell corporation or somewhere to hide money. So that's where it came. And it requires the association to file information about the association as well as beneficial owner information about each of the directors. And that information has to include the name of the director, their date of birth, their residential street address, as well as one identifying document that gives them an identifying unique a number assigned to that person. And the examples are state ID, driver's license, or passport. This all has to be filed by January 1st, 2025 with FinCEN. And it also, within 30 days of any change of any of that information, that update has to be filed with FinCEN. And FinCEN has its own portal that you can easily do this and sign in and update the report or file your report. But it has to be done by January 1st, 2025. And keep in mind that there's efforts, various efforts, trying to, by CAI and others, trying to get an exception to associations, or at least an extension until next year, so that the parties involved can maybe reach an agreement that it's not applicable to associations. But right now it is clearly applicable. I mean, there's a FinCEN FAQ that says very clearly that they have determined that board members are beneficial owners because they have substantial control over the association, and so they have to file this information. So what we're recommending, first of all, we are going to be providing this for anybody who wants us to handle the process for them. And we are still in the process of putting together a program, but what it's going to include is a subscription for a year, which would include filing the report, the initial report, by January 1st, 2025, as well as any updates throughout the year following the signature date of the client that signs on with our program. Hopefully we have that information to you soon, what that all entails, but we will be doing this. You don't have to pay anybody to do this. You can do it yourself, but what you have to understand is you then have to monitor it and make sure that you comply with any needed updates throughout the year, because there's pretty severe penalties if you don't, for willful noncompliance. And so if you get onto our website, you'll see one of the most recent blogs has to do with the CTA and what's required, where you can log on to see the FAQs, what has to be done, and what we're going to be doing to help you. So sorry, that was just a quick, there's a lot there. So we did have a webinar that went through it, and I think it was Alina that did it. So check on our website. She actually went through the slides of FinCEN to show you what needs to be done and how it needs to be filled out. Can the board go, I'm going to stop at 1:30, but I think I'm almost done. Can a board go straight to the court to amend declarations insurance requirements without homeowner vote? No, because you're going to have to, under the court petition process, you have to show a couple things. And one of those things is you try to get approval from the homeowners. So you have to establish that you either held a vote or you did a mail ballot process, and establish that you got at least half of what is required under the current declaration for amending the declaration. And then thank you for a great presentation. You're very welcome. One more on the declaration. This is the last one. On the declaration amendment, if the current documents say 50% is quorum, but 67% is the vote, and the first meeting had 50% present, can a second declaration amendment still go through? No, I mean, no declaration. If a declaration, I mean, the first statement here says if the declaration amendment is 50% of a quorum, that already in itself is invalid because it doesn't fit within the range that's required for Kiowa. And Kiowa says anything from a majority of all to 67% of all. So it has to fit within that range. Okay, I think that is it. Yep. Thank you so much, everybody. And thanks for those who stayed on for all the questions. If you have any other questions, you need to reach out to me. There's my email address, and I appreciate you all staying. Have a great rest of your week.